Hi class, this is Administrative Law 2, and in this situation what I'm going to do is give you a real life example that I'm very familiar with. At one point I was chair of the Michigan Employment Relations Commission. It was a state commission. It was enabled by a state law, well several. One of them was called PERA, Public Employment Relations Act. Another one was called Act 312, and that had to do with arbitration. Another one was called the Mediation Act, and that had to do with mediation in Michigan. And so what we were charged with doing is making sure that there was labor peace among employees and employers in the state of Michigan. And so these acts enabled our existence. They gave us our power. And some of the things that we did as an administrative agency are as follows. As I said before, we controlled the relationships between the union and the employer. We made sure that they adhered to the acts. We also looked at and monitored negotiations and made sure that strikes did not occur. We provided mediators for free to assist with negotiations or problems, disputes between employers and employees. We provided arbitrators for major disputes. And then if an act had been violated, we provided an administrative law judge who heard the case and decided whether or not the law had been violated. Now, underneath us was an agency, and the agency basically provided us with administrative law judges, arbitrators, mediators, and negotiators. And there was a regional director over them. And the regional director, they responded to us. We were, in essence, their boss. Now, let's say the ALJ received a complaint that, in fact, one of these laws had been broken. The ALJ, just like a regular judge, only they are specialized in these laws, which are very complex, would hear the case just like it was a court case and write a decision. If either side didn't like the decision, then what they could do is they could appeal up to us at MERC, and we would write a decision. And there were 3 of us on there. And when you get on MERC, you're appointed by the governor, that's the executive body, and then the Senate confirms you. So there were 3 of us on that board, and we had to make a decision of whether or not the ALJ's decision was right. We would write a decision, and if we thought the decision was right or wrong, we would write it. And if either side did not agree, then they had to ask the Court of Appeals to hear the case. The Court of Appeals might grant certification and hear the case or might not. But let's say that they did, and they overturned MERC, or let's say that they sustained MERC. Either side could then go up to the Supreme Court. And the Supreme Court of Michigan, not the U.S. Supreme Court, but the Supreme Court of Michigan would then decide whether or not they wanted to certify the case, and they would hear the case, and they would let the parties know if in fact they had affirmed the decision of the Court of Appeals or of MERC. I hope this has been of some help. Thank you very much, and I'll see you in class.